Okay. So we shall start with our discussion, that is ostensible owner. Transfer of property we were discussing. Section 41, ostensible owner, is the chapter that we will discuss today. Before that, let me just tell you that you have to keep it in mind that ostensible owner concept is redundant right now because Benami Transaction Act 1988 has come into force. So right now, the concept of ostensible owner is absolutely redundant, except in some cases where only the property is held by a Hindu co-partioner for the benefit of other co-partioners, or uh, in a case it is held by a trustee for the benefit of other persons. In barring those cases, the concept of ostensible owner now has become redundant. Nevertheless, we shall study it because it is an important concept. And before Benami Transaction Act came into force, it was very much relevant, and it was deciding most of the questions where a transferee was disappointed because there was a person who was attempting an alienation, not being the real owner. So for that, we have to know what is ostensible, what is an ostensible owner, what is the rights of the transferee who is at any distress because the transfer was done, and right now it is alleged that it is alleged by the real owner that the transfer was not done properly because the transferor who transferred it was not empowered to transfer per se. So now, what is the right of the transferee who has been right now in distress? We'll discuss them one by one. So let's just proceed to our discussion today. So it has become very slow. Okay, till it opens, let me tell you what is an ostensible. What ostensible from the dictionary meaning of ostensible would be seeming like an owner, seeming from the apparent face of it, but truly he might be the owner or not. That is not a material here. Here it is only material whether he is in fact uh, some glitch. Yes, we are now back with it. Yes. So the topic for today is ostensible owner. Now it is given under section 41 of Transfer of Property Act. The object of this concept, though now has become redundant, before that it was relevant. And what was the object? It was to curb the evil of Benami transaction. It also acts as an estoppel against the real owner of the property when he is allowing another person to transfer the property which was not which he was not uh, empowered to transfer. And it also provides an equitable remedy to a transferee or to a bona fide transferee who has gotten the same for consideration without having the notice of the fact that the real owner is another person, and the person who is now right now transferring is only an ostensible owner. We have discussed many times what is ostensible owner. So ostensible means appearing to be true but not necessarily so. So ostensible, the literal meaning of would be that upru dekha jauchi. Upru dekhila belaku laguchi, or from all probability anyone would be under that impression that he is the true owner. He might be the true owner, he might not be the true owner, that is immaterial. Only relevant factor here is that it is appearing to be true. Then it is called ostensible. And what is an ostensible owner? That means all indications of ownership are there. So basically, from the face of it, you are seeing that he has all elements of ownership. Whether he is actually the real owner or not, that is immaterial. Actually, real owner ହେଇଥାଉ ନ ହେଇଥାଉ, ଯଦି ଲାଗୁଛି ତା ପାଖରେ ତା ଉପରୁ ଦେଖିଲା ବେଳକୁ ଯେ he is the owner because he has all the indications of a real owner, then he'll be known as an ostensible owner. Uh, you, it is different from the section 38, how it is not merely a qualified owner. In section 38, we were discussing that he was only capable of transferring under certain circumstances. But here it is not such. He is not a qualified owner, but apparently he seems like a full and unqualified owner. And if you take an example, you will be more clear. How do you know? How do you distinguish between who is a real owner and who is an ostensible owner? So basically, a suppose ଗୋଟେ example ଆପଣ ନିଅନ୍ତୁ ଯେ ମୋ ବାପା ଦେଖିଲେ ଯେ ମୋର ତାଙ୍କର tax ଅଧିକା ପଡିଯାଉଛି, so he thought it is proper to probably purchase a property in my name. Purchase a property in my name. He purchased a property in my name, but he paid the consideration thereof. So right now, to the world, because it is in the name of recorded in the name of myself, to the world, I seem like an owner. I seem like an owner. I seem like an owner, though my father has paid the consideration and he is the real owner because he has paid the consideration. He wanted to avoid taxes, and that's the reason he purchased it in my name. So right now, though he is the real owner, to the world, I am the ostensible owner. Even though it is not a fact that I am the real owner thereof, because it was recorded in my name, I am an ostensible owner. It can also be for the fact that not only it is required, the requirement under section is not that only uh, he has purchased it is in his name, but also if it is happening like that, that suppose for example there is a person A who has a bungalow at Goa, but he is staying in USA, and right now he has given the keys of the bungalow. He has empowered the caretaker who is acting as his agent to give it on rent, put it on Airbnb, or do whatever it feels like in order to make sure he maintains that property. So he is empowering everything. It has been empowered by the real owner. Now to the world, he seems like he is the real owner. Though he is not the real owner, he seems like the real owner. So putting things simply, you will have to remember that ostensible owner is a person who is not a real owner. He might be a real owner, he might not be a real owner, but he appears as a real. If it is he is appearing and from appearing from the face of it that he is a real owner, then it is sufficient to establish himself as an ostensible owner. He can be a complete stranger if he is empowered by the real owner to act as an owner and the world thinks him to be the real owner, then he can still be an ostensible owner. In Jayadayal versus Bibi Hazara, many considerations were given by the court to determine how to consider whether he is an ostensible owner or not. So the court had that subjective question. It is a subjective question, and it is to be decided on the basis of facts and circumstances of every case. So whether he is an ostensible owner or not to differ from case to case. And what are the considerations to be taken? Source of purchase money. As I told you, who paid the purchase money? Who paid the consideration for the transfer? In the example that I gave, though the property is recorded in my name, who has paid the purchase money? So from that we have to consider that. Then who has the possession? So who has paid the consideration money? Another person has had the possession thereof. That has to be considered. Nature of the possession, whether he is in actual possession, whether he is in constructive possession, that will be considered. Then motive for giving uh, Benami transaction. Motive for giving Benami color to the transaction. Why the transaction was given a Benami color? That will also be considered. Benjamin, it has happened. Benami has turned into Benjamin because of the autocorrect feature. Anyway, motive for giving Benami color to the transaction, that has also to be considered. Relation between the real owner and the ostensible owner, that is also to be considered. Tar bapa puo, ki swami stri. What is the relation between the real owner and the ostensible owner? That is also to be considered. Who had control over the property? Whether he was doing all the taxes, whether he was taking care of the property, whether he was giving some rent, whether he was empowered to transfer or make necessary changes, what control the person had over that property, that will also be considered. Conduct of the parties, how the parties behaved before the world, or whether the real owner allowed that person to behave like a real owner, that will be considered. Custody of the title deeds. Who had the custody of the title deeds? Arota, Khatata, kaha pakhare achi. Those things will be considered as well. So all these things will be considered while deciding whether the person is an ostensible owner or not. So now coming to section 41 and the ingredients thereof, that in what case we will think that the ingredients of this section has been met, and accordingly the person will be the transferee who is in distress will be allowed to claim the benefit of this section. The first ingredient is that the transferor is the ostensible owner of the property. So here there is a transfer of property, and the transferor who is transferring the property is the ostensible owner of the property. Ostensible owner, that means, is not the real owner. He might be the real owner, he might not be the real owner, but he appears as such. He appears as a real owner. We discussed what is an ostensible owner. So transferor is the ostensible owner of the property. Second ingredient is that he is so with express or implied consent of the real owner. So here the real owner has empowered him to become an ostensible owner. So real owner has done something either given express consent or given implied consent to make sure that this person right now acts as an ostensible owner. So we have to also see that the consent must be a free consent, and the person who is giving the consent, he must be capable of making a valid consent. That means the real owner must not be a minor, unsound person, and he must not be put under undue influence, coercion, fraud, misrepresentation, and he has given a consent which is either express or implied. So these are the first two ingredients. First is that the transferor is the ostensible owner of the property. Second, he is so with the express or implied consent of the real owner. And that consent must be a free consent and capable of making a valid consent. What is an express consent? That is when, in clear words, the owner is authorizing a person uh, that you are now the ostensible owner, or you are now to act as an owner, then it will be express consent. Or implied consent is when the real owner knows his rights but stays silent. But basically here you are sleeping over the right. You are seeing that the other person, you have actually paid the purchase money. You are actually the real owner. Right now, the person in whose name you had purchased it, now he is trying to transfer that property. Now, whether instead of objecting, even though you knew that you had certain right, you stayed silent. Then that is an implied consent. If by giving such consents, he makes everyone believe that the other person has power over the property, he has all the powers over the property. ସେ ରହୁଛି ସେଠି ଗୋଟେ ବଙ୍ଗଲୋରରେ ସେ ରହୁଛି, ତା ପାଖରେ ଟାଇଟଲ ଡିଡ୍ସ ଅଛି, ସେ ଭଡା ଦଉଛି, ଭଡା କଲେକ୍ଟ କରୁଛି, ରେଣ୍ଟ ପେମେଣ୍ଟ କରୁଛି, taxes payment କରୁଛି, he is defending suits, he is filing suits on the behalf of the bungalow. So all these rights that he has, then to the world he will seem like a real owner. Even though he is not the real owner, he will seem like a real owner. So in this case, it will be deemed that he is the transferee, the transferor has given implied or express consent thereto. So this is a leading case, Ram Kumar Kunudu versus McQueen, 1872 case. On the basis of this case, the concept of ostensible owner, in fact, was uh, formulated. So in this case, what happened was that I'll tell you the facts of the case. That here one person uh, named A purchased some landed properties. So he purchased certain landed properties in the name of his mistress. So he was having an affair with a person and he purchased certain landed properties in her name. Now, from that mistress, two children were born, and that one of them actually filed this case to this is the that is the case that has been filed. And what happened in the meantime was that the sale deed was in the name of that mistress, and she was to also manage the property. So here Alexander A, he purchased that property in the name of his mistress. He made sure that the sale deed was made in her name. Now she was also managing the property, and he uh, so now the mistress is actually selling that property to another person. That mistress sold that property to another person. Now, when uh, the son of that Alexander, son of A, is filing a case against uh, that mistress, saying that you were not allowed to make a transfer because the purchase money was paid by my father, and he was in fact the real owner, in which the Privy Council held that this is in fact the concept of ostensible owner. So the purchase money was paid by some other person, but the property is being managed and the taxes are being paid, and she's selling that property. Now the bona fide transferee for consideration will not be put in distress, and he will in fact be he will in fact be getting that property free of any charge or free of any hindrance. So that is in fact the concept of ostensible owner, which came from this Ram Kumar Kundu versus McQueen case. So again, the third ingredient, we discussed two ingredients, that transferor is the ostensible owner of the property. Second is he is so with the express or implied consent of the real owner. Third is transferor transfers the same for consideration. So if it is a free transfer, if it is a gift, if it is a gratuitous transfer, then it will not be valid. Here, for this concept to come into picture, the transfer must be for consideration. Any kind of transfer that can be done, lease, sale, mortgage, any kind of transfer, that is fine. But only thing is that it must not be gratuitous, it must be for a consideration. So the ostensible owner here is transferring that property to another person for consideration, and the person who is getting that property, that means the transferee, he has uh, tried to ascertain that transferor had power to make the transfer after exercising reasonable care. So the transferee exercised reasonable care and ascertained that the transferor had power to make the transfer. So he did not know that he is the ostensible owner or he is not the real owner. He thought that yes, now right now he is managing the property, it is recorded in his name, though even though it was purchased by the purchase money of some other person. After ascertaining, after making reasonable care, I am finding that the transferor had power to make the transfer. So, what is the reasonable care? That he must exercise the care that will be exercised by a man of ordinary prudence. And he has no notice of the real fact. That is, he does not have the notice of the fact that there is another person who is in fact the real owner, and this person is the ostensible owner, and he is not empowered to make that transfer. If all these four things are done, and another fifth thing is that the transferee acted in good faith, because here we are trying to protect the right of the transferee, then now the transferee must prove that he is coming with clean hands and he had bona fide belief and he was honest. If all these five ingredients are proved, that is, first is transferor is the ostensible owner, that means he is looking like an owner of the property, looking like a real owner of the property, even though he's not the real owner. He is done as such with the express or implied consent of the real owner. Third is transferor is transferring the same for consideration. Fourth is transferee, after taking reasonable care to ascertain that the transferor had power to make the transfer, is satisfied that yes, in fact, transferor had power to make the transfer and the transferee acted in good. All these five ingredients are satisfied, and then the effect shall be that the transferor shall not be voidable on the ground that the transferor was not authorized to make it. Now, just because the transferor was not authorized to make it, the transferee right now who has obtained it in bona fide manner without having notice of the fact that there was another person who was the real owner, he will not be put in distress, and the real owner will be prevented from disputing the validity of such transfer. But the burden of proof is on the transferee, that he has to prove that how he was not under the belief, or how he had reasonable care, he had exercised reasonable care and ascertained that the transferor in fact was authorized to make it. He thought so, even though the transferor was not authorized to make it, that is immaterial. He exercised reasonable care and he found out that the transferor was authorized to make it. Then in that case, the real owner will be prevented from disputing the validity of such transfer. So again, another concept comes, that is doctrine of holding out. This is the effect thereof, that here there are two persons who are claiming interest over the same property. One is the real owner, and this other person is the person to whom the ostensible owner has transferred. That means there is a person to whom the ostensible owner has transferred. He is the transferee in distress. He is claiming right over that property. The real owner is also claiming right over that property. Now, who will come out as winner? Who will be holding it out against the other person? That is, in fact, the doctrine of holding out. It says when the rights of two innocent parties are involved. When I'm saying innocent, the real owner, in fact, is not really innocent. He is having certain problems because he tried to uh, cheat the system by purchasing it in the name of other person, or he had some other motive. Either he wanted to evade taxes, either he wanted to make sure that he does not get any permission from the government, and he still purchases the property. So he had certain motive. So right now, the between two innocent parties, the party who is more innocent, he will be in fact protected. So between the transferee who is in distress, who has been put as such by the transfer of the ostensible owner, and the real owner, uh, the real owner will not be allowed to go against the interest of the transferee in distress, and he will be held out by the transferee in distress. So, and that the reasoning behind is that who allowed this to happen? Because I allowed that person to act as an ostensible owner, then only he transferred it. मुझे ताकू न କହିଥାନ୍ତି, मुझे ताकू न ଦେଇଥାନ୍ତି right to act as an ostensible owner, ମୁଁ ତାକୁ ଯଦି ତା ନାଁରେ କିଣି ନଥାନ୍ତି और ତାକୁ right ଦେଇ ନଥାନ୍ତି, ତାକୁ title deeds ଦେଇ ନଥାନ୍ତି, ତାହେଲେ world ର ଅଲଗା ଲୋକ କାହିଁ ଭାବିଥାନ୍ତେ କି ସେ ostensible owner. I allowed it to happen. So now I must suffer. The real owner must suffer because he allowed it to happen. So he is innocent as such because he he actually did not transfer it, and the other person who is transferring it has no, in fact, no power to transfer, but he is an ostensible owner and he transferred it. The other person got it. Now, who is more innocent here? The transferee, he had no notice thereof, but here the real owner is having certain problems. That is, he had given that consent, he had given express or implied consent, he made sure that the ostensible owner is preached as an ostensible owner to the world. Then, in that case, the transferee is protected. The transferee is protected and he is entitled to hold out against the real owner. Now, I also told you that after coming into force of Benami Transaction Prohibition Act, this concept of ostensible owner has somehow become redundant. Because Benami transaction, what is a Benami transaction? That is when I purchase it in the name of another person. I am paying the consideration, but because of the fact that I intend to evade taxes or I intend to escape the liability of certain kind, I am purchasing it in the name of another person. So basically, if there are people who have a lot of black money, so they want to purchase in the name of other persons, their brother-in-law, their sister, their mother. So they will purchase in their name. So right now, the Benami Transaction Act, Prohibition Act says that in whose name it has been bought, he will not be ostensible owner, and he in fact will be the real. So even if my father purchases a property in my name and he has paid the consideration, by virtue of this act, he will not be allowed to say that I am the real owner thereof. In fact, the ostensible owner or the person in whose name it has been bought, he will be the real owner. So if that has happened, now the concept of ostensible owner and section 41 will be redundant. How? Because I will be the real owner. If I transfer it to someone, he will get the property free from any problem or any encumbrances. So that is not a problem. So here, by virtue of this act, there is no applicability of section 41 right now, except in certain cases. That is, if the property is held by a co-partioner, held for the benefit of other co-partioners or benefit of the Hindu undivided family, or held by a trustee for the benefit of others. So in these two cases only, the concept of ostensible owner will be applicable. So if the trustee holds, then it can be the concept of ostensible owner can be applied. Or if Hindu co-partner holds, then the concept of uh, 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 um, ostensible owner can be applied. But in rest of the cases, the Benami Transaction Prohibition Act makes sure that the doctrine of ostensible owner is no more active. Now coming to section 42, that is transfer by person having authority to revoke former transfer. This is a very simple section that says that where a person is transferring a movable property, any movable property, and he is reserving the power to revoke the transfer. He is reserving the power to revoke the transfer. So here is he transferring an immovable property, but he says that I have the power to revoke the transfer, and in fact, I will say if you do something, then I can say that this property will not go to you. If I am making certain clause like that, and he is subsequently transferring the property for consideration to another transferee, then in that case, the effect would be that such transfer operates in favor of such transfer, because I had kept the power of revoking the transfer. Right now, I'm transferring it to another transferee. Now, such transfer operates in favor of the transferee, subject to the condition attached therein. So, if I have to the example, if you take, then it will be more clear. That is, I have given that, I have given a house on rent to my friend, and saying that if you do any illegal activities here, then I will not give it on rent anymore. And then I probably thought that he is doing something wrong, and I sold that property, or I rented that property to another person. That is another person C. So in that case, it will be presumed that such further rent has taken place. Now the transferee, the, the subsequent transferee will get it free from any problem because of the fact that I had reserved that power to revoke the transfer. So if I had reserved that power to revoke the transfer and I am transferring a property and subsequently transferring it to another person, then such subsequent transfer shall take effect in favor of such transfer, and it will be deemed as if the former transfer has been revoked because I had kept that power with me to revoke the transfer. This is a plain section where mainly we wanted to discuss section 41. Section 42 was also there, so I thought we shall discuss that as well. Anyway, if there is any doubt, please ask, or we shall end up the session here. Pritiman has a doubt. What is the doubt, Pritiman?
Sir, good evening, sir.
Good
So
evening.
section 42 in Barrett, the illustration where the person transfers an immovable property, reserving power to revoke the transfer. I didn't got this point, sir.
The
Section
point
40.
here is that I am transferring a property saying that on the happening of certain event or on the doing of certain thing, I will not transfer that property to you, or I will revoke that transfer. ମୁଁ ଏବେ ଆପଣଙ୍କୁ ଗୋଟେ ଜିନିଷ ଦଉଛି କହିକି that ଏଟା ରଖିଥାଅ, ଯଦି but ତମେ ଏଇଟାକୁ ଏମିତି କିଛି କଲ, then I will take that property back. Right now, ଏବେ ମୁଁ କଣ କଲି ନା, without doing anything or without taking it back, I gave it to another person. If I gave it to another person, that will be presumed that the former transfer is revoked, and subject to the condition that yes, you have done that thing. जो ପାଇଁ ମୁଁ କହିଥିଲି ଯେ ଏହା କଲେ ଆପଣଙ୍କ ଟ୍ରାନ୍ସଫରଟା ରିଭୋକ୍ ହେଇଯିବ, ଆଉ ମୁଁ ତାକୁ କହିକି ଅଲଗା ଗୋଟେ ଲୋକକୁ ଦେଇଦେଲି, ଏବେ ସେ subsequent transfer will take place because I had kept that power to revoke that transfer with
Thank you.
you. Welcome. Okay. So I believe, yes, today the class timing was 8, but from tomorrow it will be 7 again. In fact, our normal time it will be 7 p.m. and we'll discuss the doctrine of feeding the grant by estoppel. That's what we'll discuss tomorrow. Have a good night. I'm tired today, so I'll not be take more time. We'll meet tomorrow. Thank you.